Okay, Donna, whenever you are ready.
Welcome to today's program. At this time, all participants are in listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On this slide, you see the legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program. Please go ahead.
Thanks so much, and thank you to everyone for being with us today. We've had overwhelming interest in this topic. It's clearly something on the mind of many of our clients and friends, and so we're very happy to be here with you today. My name is Dawn Soloway, and I'm a partner in our Boston office. I am a member of our national trial team as well as our national appellate group, and I do both employment litigation and counseling. And so the issue of jury verdicts and how to overturn jury verdicts is near and dear to my heart as someone who practices in both trials and appeals. And here with me today is Lynn Kappelman. Lynn is also an employment litigator and counselor. She is the head of our national trial team, as well as a member of our pharma and retail industry groups, and has really spent her career studying juries and jury verdicts. And so that's why she is helping to present today. Next slide, please. So just want to preview for you our agenda for today. We're going to be talking about trial trends, introducing you to your 2023 jury, and talk about some of the reasons that we're seeing so many explosive verdicts. We're also going to talk about what are called reptile tactics, which are some of the strategies that the plaintiffs' bar are using to try to secure one of these explosive verdicts. And then we will be talking about some strategies to fight back and some considerations for post-trial and appeal in the event of an adverse large verdict. And we wanted to kind of preview these topics for you so that you don't despair as we are talking about the trend itself and the prevalence of these verdicts, because there really are strategies to try to both prevent and, if necessary, remit those verdicts. And so we will be getting to those in the sort of second half of the presentation. Next slide, please. So let's talk a little bit about a 2023 jury and why we're seeing such an explosion in huge verdicts. We're all reading about these in the news, and I'm sure some of you are hearing about them in your companies and among your fellow in-house attorneys. But basically it's a trend in what are sometimes called nuclear or explosive verdicts that are just completely irrational, disproportionate to the facts or the law of a particular case. And correspondingly, we're seeing a lot of huge settlements and huge settlement demands because a lot of plaintiffs' lawyers are convinced that the verdict in their next case is going to be one of these explosive verdicts. Next slide, please. And so just let's spend a moment talking about why. One, it's really important not to underestimate how raw people are from COVID. Right, we're coming out of 3 years of a pandemic, COVID disruptions, fears, divisions. There's also a lot of increased prejudice against anyone who is kind of conceived to be an other, and stronger bonds between people of the same or similar background. At the same time, in times of stress, social science tells us that people are prone to sort of thinking more intuitively rather than through logical processing. And so that kind of makes jurors primed for these kinds of explosive verdicts. As a country, of course, we're increasingly polarized. And, honestly, we're seeing that not only in large verdicts, but really across the labor and employment space. And I'm sure that many of the attendees on this call are seeing it as well, where these sort of cultural flashpoints and political polarization, religious divides, debates about diversity are really spilling over from the culture and the world around us into the workplace. Here at Seyfarth, we have recently established a group that is kind of dedicated to navigating cultural flashpoints in the workplace, both on the employment counseling side and on the litigation side. And that's all something that is also contributing to these explosive verdicts. And then anti-corporate sentiment, which is, as we all know, very prevalent in both of the major political parties, kind of a sense that companies are bad and are out to get the little guy. And that is something that plaintiffs' lawyers are very much trying to tap into. Next slide, please. We're also seeing a loss of trust in institutions. You can see from this chart, which is from 538, that Americans' trust in institutions is at an all-time low. And what that means in terms of jury verdicts is that, the employer, the company, the hospital, the college is not something that jurors are necessarily inclined to trust in. And may kind of enter the courtroom very much in a position of distrusting the employer before they've even heard the judge read the description of the case. Next slide, please. There are also a lot of other sort of cultural factors that are playing into the large verdicts. So there's, of course, the Me Too movement that brings a whole new lens for many jurors on any kind of gender or pay equity issues in a case. The Black Lives Matter movement that is very present in the minds of jurors as they're listening to evidence about anything having to do with race or national origin. The concern about income inequality, and which of course plays into the idea that here's this deep pocket corporation and this individual plaintiff, and that can, for some people, kind of put them in a frame of mind where they're interested in kind of trying to use their verdict to level out that playing field. The quiet quitting movement, the idea that some of the arguments that we might make in an employment case about performance issues or someone kind of not bringing their best work to the workplace may not resonate in the same way that they used to. And then concerns about pay equity and a lot of sort of distrust of companies in terms of how they pay people based on gender. Next slide, please. And I think another thing that is really driving this trend is the way that verdicts are portrayed in the media, and in particular on social media. And verdicts are now going viral on social media within seconds of being read in court. And they're often framed not just as an individual verdict in an individual case based on specific facts and law, but rather as kind of a broad cultural statement. And so, here on this slide, we see E. Jean Carroll, who, after her recent verdict, said, "This victory is not just for me, but for every woman who has suffered because she was not believed." Or Amber Heard, in her trial that she lost, "I'm even more disappointed with what this verdict means for other women. It is a setback. It sets back the clock to a time when a woman who spoke up and spoke out could be publicly shamed and humiliated. It sets back the idea that violence against women is to be taken seriously." And so, people, ordinary people who are reading these social media accounts are, of course, the people who are going to be jurors, next week, next month, next year, and are hearing not only, large verdict amounts in the media and social media, but are hearing that they are a way to express a viewpoint or frustration, to sort of level the playing field. And all of that is kind of coming into the courtroom in these cases. And the idea that an individual verdict is a means to send a message is kind of the essence of the reptile theory that plaintiffs' counsel use. And Lynn is going to discuss the reptile theory.
Thanks. Next slide, please. And then one more time. So what is the reptile theory? You may be sitting there saying, I've heard of this reptile theory, but it makes no sense to me in the scheme of litigation. The reptile theory is a tactic that plaintiffs' lawyers use, and the reason it's called the reptile theory is a legal strategy to call on the most primal or reptilian fears of jurors. And by that I mean it suggests to jurors, in order to avoid danger for you, for the entire public and the entire community, you need to rule against this defendant and in favor of this particular plaintiff. And that's something that is clear and obvious and has been used in sort of products liability cases. That's where you can imagine if this defendant had put a warning on this tool, Joe wouldn't have cut his arm off. And so we need to send a message to this manufacturer that they have to put warnings so that we don't all cut our arms off. And it appeals to sort of the most primal safety fear of a juror. But you say to yourself, well, how does that bleed over into an employment case? Well, the same kind of theory works. You say, plaintiff's counsel may say, the employer has established a safety rule or an anti-discrimination policy or a complaint policy, and they didn't follow it. And now we're all in trouble. And shouldn't all of us be able to complain about discrimination without fear of retaliation? And so it takes something that happened to a single plaintiff and it creates something that happened to the entire community or could happen to the entire community if these jurors don't punish this defendant. And so it's basically a means of holding the defendant accountable for creating an unsafe condition or for breaking a rule that we all rely on and makes us unsafe or anxious. And so it creates terrible consequences, and you should punish the defendant so we're all safe. Next slide. So what do they do and how do they do it? Plaintiffs talk a lot about we, our company, our community, and us. This company let this man into our homes. You know, that's what they used to do with, like, cable folks. When there was some sort of cable guy came and did something terrible in a house, the company was responsible because they let this man into our homes and we trusted him. And in an employment case, what they'll do is they'll talk about prior reports of discrimination where the company didn't do something about it, didn't fire the discriminator, didn't fix the bad act, didn't remedy the problem after an investigation, or didn't do a proper investigation. They'll talk about prior verdicts against the company, whether those verdicts have anything to do with the current case, to make you think, here's a company that just doesn't take these complaints seriously. And so the actual facts of the case become secondary, right? How much harm could it cause in other situations, ladies and gentlemen of the jury, if you don't slap this defendant on the wrist? And by the way, when you slap them on the wrist, make them pay attention. And how do you make them pay attention? With a large punitive damages award. And that's why you're seeing these explosive punitive damages awards, because what plaintiffs' lawyers are doing is they're appealing to the primal fear of the jurors that if they don't send a large punitive message to this defendant, then we're all not safe. We're all in danger of the same thing happening to us. And so that's the reptile logic. Next slide. Specifically, how are we seeing it in litigation and in cases? You'll see incendiary arguments right from voir dire. You'll see them resort to passion and passionate language and prejudicial language. What do I mean by that? Well, you may see a lawyer in voir dire say something like, ladies and gentlemen of the jury, would you be able to hold a company liable if it permitted abusive and toxic environments and ruined careers like the plaintiffs? And those kind of words that right from the get-go, these folks don't even know what this case is about, and already they're being led to believe that the company has an abusive and toxic work environment that would ruin a career. the kind of thing that nobody would really want to work in, right? And you'll also see plaintiffs invest in more resources into cases. I'm constantly scratching my head these days because I'm like, this is a single plaintiff employment case about age discrimination, and I have, answered 75 interrogatories and had to do ESI discovery on every possible discrimination claim that was ever brought by the company. So you'll see larger, broad-based discovery requests, creating larger fees, obviously, burdensome deposition requests. You'll see requests for 14 depositions in a single plaintiff case, when that would have been unheard of a few years ago, right? I mean, the notion that you could take depositions of 10 or 14 people in a single plaintiff case just doesn't make sense, but you're going to see that. Very aggressive cross-examination of witnesses, pushing on whether attorney-client privilege really even protects documents in a way that used to be sacrosanct. When you would say, oh, this document is privileged because it was a conversation between counsel and the client, no longer sacrosanct. Plaintiffs will push hard on that and try to get all those documents in, and sometimes they'll get a sympathetic judge, unfortunately. And very dramatic use of hot documents and bad emails in a way that we haven't seen before. So right up in front in the opening statement, you'll see them blown up large in the opening statement, used in voir dire, used during questioning, etc. So I think the efforts during discovery are to make defense witnesses look evasive, insensitive, deceitful, negligent. What do I mean by that? Here's how it plays out. So you investigated this, but you only spoke to 2 witnesses? Why didn't you speak to the other 17 people at the breakfast party where this incident was alleged to have occurred? And maybe at the time, that didn't seem like an appropriate scope of the investigation, but plaintiff's lawyer will make it look like the investigator was lazy, insensitive, uncaring, didn't do their job because they didn't talk to all 17 people at a particular gathering when they did their investigation. And those are the kinds of tactics you're going to see. It's overblown, out of scope, and used to be the kind of thing that when you went to a judge and you tried to shut down, you were successful. We're not as successful these days shutting that down. Next slide. Back one, if you don't mind. Yep, okay. So the other thing that we're seeing is what we often do, and Dawn will talk about this, is we'll be able to anticipate some of these reptilian tactics because we've seen it during discovery. So we will move in limine to keep certain things out that are, incendiary or prejudicial or not really relevant, more prejudicial than probative, and we'll win. And instead of letting it go, these particular plaintiffs' lawyers will continue to try to slip this information in despite an adverse motion in limine ruling. They'll poison the well with the jury so the jury hears it and can't unhear it, and then they'll say, oh geez, gosh, I'm sorry that came in. They'll mischaracterize evidence so that you're constantly objecting, looking as though you're trying to hide the ball when you object, when in fact you're just trying to get the true facts into evidence. They will anchor. They'll suggest a specific high verdict number and specific high punitive numbers in an effort to say you need to send a message and you need to punish. They'll literally say punish, the corporation so that this corporation and other corporations don't do the same thing. They'll be heavily coached. Plaintiffs will show crocodile tears, the likes of which could flood out your courtroom, and you'll see it again and again. And by the way, it's not 1 or 2 lawyers. Plaintiffs' bar actively shares these tactics. They talk about it, and they are all doing it these days. And so you need to really keep a close eye on it. Next slide, please. Is it okay? Why are we seeing it now? Why haven't we seen it before? Well, here's the thing. It is an improper appeal to jurors' concerns about their own safety and the safety of the community. It is irrelevant what these particular jurors think. What we want to do is try to focus the case back on the plaintiff, back on what the plaintiff saw, heard, experienced, and what the defendant or the employer did in response, and try to get it out of sort of the community and the public danger and safety concerns. And Dawn's going to talk a little bit about the ways that we suggest you do that. But, you know, it has always been true that the golden rule is not permissible in almost any court, state or federal. And what is the golden rule, ladies and gentlemen? It is saying to a jury, ladies and gentlemen of the jury, put yourself in plaintiff's shoes. If you were standing in plaintiff's shoes, how would you feel about X, Y, or Z? Believe it or not, that is impermissible in almost every courtroom, right? And yet, what has happened is plaintiffs' bar have figured out a way to subtly get around that by appealing to jurors' primal fears about the community or dangers to the public, rather than saying, put yourself in plaintiff's shoes. And so rather than focus on whether defendant's contact in this particular case caused injury to this particular plaintiff, these plaintiffs' lawyers will ask whether defendant's contact represents a larger community danger. And listen closely for that. Move in limine if you can. Object. Have a sidebar with the judge. Dawn and I had a trial once where a plaintiff's lawyer, literally during closing, said to the jury, now imagine, I'm not sure why he did this, but he said, now imagine, ladies and gentlemen of the jury, if you were sitting in that jury box and somebody drove a truck right through the jury box and there were people laying maimed and bloodied right next to you. We're sitting here going, what does that have to do with the employment case that we're trying right here? But thank God the judge, who was a seasoned jurist, said, sidebar, please, and said to the plaintiff's lawyer, you know you're not allowed to tell jurors to put themselves in the plaintiff's shoes. And I'm not sure what you're trying to do with this truck through the jury box thing, but if you're trying to use the golden rule, stop right now. And that's the kind of thing that I'm telling you, is to talk to your lawyers and make sure that they have a sidebar as soon as these kinds of things start to happen, and shut it down as best you can. Next slide. Now, Dawn's going to give you a few strategies to fight back when you start to see these things happening both in discovery and in the courtroom at trial. Dawn?
Yes, thank you. Next slide, please. So there are a lot of great strategies to fight back. And I think step one is being educated about these tactics so that you are fully equipped to be able to fight back right from the beginning of a case. And, you know, just kind of building on what Lynn was saying about why the reptile theory is improper, you know, it violates the bar against appealing to the self-interest of jurors. It threatens the jury's impartiality. And litigants have a constitutional right to a trial of their claims before an impartial jury. So this is seriously improper. It's improper for counsel to ask the jurors to put themselves in the shoes of a party, as Lynn was alluding to, because it invites the jurors to become partisan advocates for a party rather than what they're supposed to be, which is objective triers of fact. And also, of course, the jury's role is supposed to be to render a verdict based on the actual evidence that's admitted at trial and not based on extraneous arguments and fears. Next slide, please. So it's really important to fight back right from the beginning of the case. And, you know, we like to tell clients that even the answer is an opportunity. So rather than just deny, 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 especially if you're faced with a sort of reptilian complaint, not to allow the plaintiff's story to be the only story that's before the court at the outset of the case. So there can be themes woven into the answer about fairness and fair treatment of the plaintiff, and at least a little bit of an allusion to why the defense, why their actions were fair and reasonable. Next slide, please. So strategic discovery, it's really important to view discovery through this reptile lens. And, you know, as Lynn was saying, it's we're seeing the plaintiff's bar be much, much more aggressive. And so it's really important for employers to be sort of appropriately aggressive as well. It may be worth motion practice to try to keep the scope of ESI discovery or other discovery proportional and reasonable, or to prevent, you know, them from taking 20 depositions in a single plaintiff case. Written discovery can be used to your advantage in sort of sussing out some of these reptile tactics. Being really, really careful with privilege issues, because we are seeing plaintiffs, lawyers try to use legitimate privilege, lawyers, in-house lawyers who are doing their job in providing advice and counsel during, say a termination or performance management. That is being kind of, plaintiffs' bar is trying to put that in front of the jurors to suggest that there was something nefarious going on, that, the lawyers were part of kind of a cover-up. And that's really improper. And so it's really important to be, kind of pushing back and alert to those issues as you go through discovery. Depositions, especially 30B6 depositions, it's crucial to make sure that the corporate representative is extremely well prepared. Because unlike kind of the 30B6 depositions of maybe 10 years ago, they tend to be much more aggressive. And again, just trying kind of overtly to put the corporate representatives in a bad light, to rattle them, to get sound bites out of them that they can blow up in front of the jury later. And so really the best defense is a good offense here in terms of making sure that they're extremely well prepared. Lynn and I like to do mock cross-examinations, and we'll sometimes do that for each other to make sure that by the time the witness is actually in the deposition, they've already seen worse in the preparation session. Next slide, please. Jury selection, of course, trying to prevent a crazy verdict will, be important to pay attention to jury selection. It's also important to avoid stereotyping based on demographics, and you really need a more sophisticated, I think sometimes, some defense lawyers will tend to kind of rely on those stereotypes, like, oh, I don't want this kind of person, or I don't want this kind of person for this case. But this really requires a very sophisticated analysis of what kinds of jurors are going to be biased against your client. And often we will work with jury consultants to do that exercise. And in particular, we're looking for at voir dire, weeding out jurors who will be especially susceptible to the reptile theory. And so, people who feel that they have been treated unfairly in their own life, people who feel that success or failure is all kind of chance, and this is a really important one, because the case is already at the trial stage, the defendant must have done something wrong. It is actually shocking how many jurors come to the courtroom thinking that if this has gotten this far, the employer must have done something wrong. And so that's a question that you can actually ask at voir dire, and judges will often be receptive to the idea that that is a person who should be stricken for cause. Next slide, please. Motions in limine are one of the most powerful weapons against reptile tactics. And here it's really important to call it out directly for what it is and to educate your judge, because your judge may or may not have ever heard of the reptile theory. And, part of what I think is effective about the reptile theory is that it is, if you're not alert to it, it can be sort of hard to suss out. And so, the sort of appeals to, sending a message or punishing, speaking in terms of we and us, those are things that aren't necessarily going to come to the judge's attention, especially, in the midst of a busy docket. And so it's really important to call it out and say, this is what my opposing counsel is trying to do, and it's improper, and citing cases that will back you up on that. In particular, reptile arguments like the golden rule, protecting the community, sending a message. Next slide, please. So, two can play this game. So, in other words, it's not only the plaintiff who can appeal to jurors as human beings and appeal to their emotions and sense of fairness. So it's really important more than ever to have a tone of compassion and empathy, to have, to express the employer's genuine concern about safety. And, for example, in a discrimination case, it's anti-discrimination policies, its anti-retaliation policies. It's important to emphasize how the employer is a good citizen and someone who employs people, and what their business is in the community, a sense of responsibility. And so all of those themes can help sort of mitigate these reptile tactics. In cases involving employee misconduct, it's really helpful to lean into how that affects others, right? Customers, coworkers, clients.
Dawn, can I tell a story?
Yeah, absolutely.
So a good story that shows this, I think, is that we had a client that was a supermarket chain, and they had fired a guy who worked at the meat counter. And he claimed he was terminated for, I think it was national origin discrimination. And we went into trial, and our theme of the case was green meat. The reason this guy was fired was not because of his national origin, but because part of his job was to take the old meat out of the case so that when you went food shopping to buy your groceries, you weren't buying meat that was, in a sense, green or old meat. And he kept not doing it, despite the fact that we counseled him on a number of occasions. And so we ended up firing him for that, not because of his national origin. And in some ways, our argument was, you wouldn't want us to let this guy keep working and keep the green meat out in the shelves so that when you went grocery shopping, you got meat that would make your family sick. And we knew it worked because when we went in to chambers, the judge said to us, my God, I shop in that market, and I'm so glad you fired that guy because I would have been picking up green meat that he hadn't taken off the shelves. And the judge is a person too, right? I mean, so in some ways, we beat the plaintiffs in their own game by saying, appealing to public safety, and nobody called us on it, so we ended up winning that case. But if the plaintiff's lawyer was smart, they might have called us on it. So I think, to me, two can play at this game, and if you can figure out a way to show that you as the company are doing what you're doing to protect everyone else. Sorry, Dawn, but I thought it was a good example.
No, exactly. And it's also really important to emphasize the people who work for the employer rather than the big entity name, because ultimately employment decisions are made by people, by managers, by supervisors, by HR. And so speaking in terms of, why did Sally or Frank decide to terminate this person rather than, insert large employer name, can be really effective, and really honest to the facts of the case. And in the same vein, diversifying witnesses, so not just putting on managers and HR. And as many of you know, that we see over and over in mock juries that there's a lot of suspicion about HR out there. Everybody has their own HR from their own workplace, their own history, and many jurors are very skeptical of HR. They are convinced that HR is not there to help them, but to help the company. And so there's a lot of kind of baggage there. And so it's really helpful to diversify the witnesses to bring in, peers of the plaintiff, or subordinates of the plaintiff, former employees who don't have as much of a vested interest in, as current employees might, to try to frame a larger picture about what was actually happening and how the plaintiff's performance or misconduct affected other people. Next slide, please. Another really important focus is limiting compensatory damages. And I think this is something that is not always obvious, but limiting compensatory damages is effectively a limit on a runaway verdict. And that's because in the event of a punitive award, and what we're seeing in a lot of these explosive verdicts is, a modest to large compensatory verdict, but then a crazy punitive verdict. And if that happens, the size of the compensatory award will act as a limit, because there are rules as to what the ratio can be between compensatory and punitive damages, in terms of whether they're unconstitutionally excessive. And the full scope of that is probably for another webinar. But what that means in practical terms is that we should be focused on trying to keep the compensatory damages as contained as possible. And so what that can mean is maybe leaning into experts on compensatory damages. We frequently will retain economists, mitigation experts, recruiters, who can talk about what is the actual absolute cap, even if you find liability on say back pay or front pay, and what other job opportunities were available to the plaintiff that they didn't utilize. And emotional distress experts, again, something that maybe we wouldn't have done 10 years ago that is now kind of under consideration because it can help to cabin in those compensatory damages. Next slide, please. And finally, the closing argument. And, this is really, where it all comes together. And where you have the most freedom as the employer to kind of push back more expressly with the jury against reptile tactics. The reptile tactics wants to make everything very black and white. Here's this safety rule, the employer violated it, they are bad. And what we like to do is to remind jurors expressly that most things in life are not that simple, that the story is more complicated than that, and to try to point out those nuances to them. Also, juries don't like to feel manipulated. They don't like the idea that a lawyer is manipulating the way they're thinking. And so if you can, again, in a approachable way, but sort of suggest that the plaintiff's lawyer is trying to sort of pull this trick on you and don't be fooled, can be a very effective way of kind of pushing back against these tactics. If there has been a mistake that the employer made somewhere along the process, which of course is not uncommon, then you might really want to think about owning some of that and kind of saying, look, this part of the story wasn't perfect, but it's certainly not discrimination or retaliation, for example. Humanizing the defense witnesses, the closing is a perfect opportunity to really do that and explain why the supervisors made the choices they made. So we're not referring to just the company or the hospital or the corporation, but the people who made those decisions. And then considering objections to a plaintiff's reptile closing. And this is, obviously fraught with peril. And as Lynn said, in the case that she gave you the example of, we were very fortunate that the judge broke in and just said, wait a minute, you can't do this. But actually interrupting a closing with an objection is dangerous territory. It certainly calls attention to, whatever it is. It can look defensive, but it also is an opportunity to preserve the argument that it is a reptile tactic that's improper. And you might actually get a curative instruction from the judge that they're not permitted to consider, for example, putting themselves in the shoes of the plaintiff. Next slide, please. So Lynn mentioned anchoring. Some plaintiffs' lawyers are doing anchoring, which means basically alluding to a huge verdict amount that, well, you'd have to give this plaintiff at least $20 million to make up for, this horrible conduct. You can, and I just want to, as a side note, say that the rules about anchoring vary a lot by jurisdiction. So here we sit in Boston, and in Massachusetts Superior Court, it is allowed. Anchoring is allowed, provided that notice is given to opposing counsel that it's about to happen so that the employer has an opportunity to rebut the anchor. And so, if you're in a jurisdiction that allows anchoring, and in federal courts tend to vary, so it's always really important to make sure you understand what the rules are in your particular jurisdiction. But if anchoring is allowed and you get notice that the plaintiff is going to do it, it's worth considering whether to throw out a counter anchor. And I think, the old rule was it's always a mistake to talk about damages, because if you're talking about damages, you're somehow conceding liability. But in this world with these huge verdicts, it's worth thinking about whether you want to affirmatively say, look, even if you find that, the company did the wrong thing here, with a verdict of X amount, the plaintiff would be more than whole. because it puts a frame around the anchor in terms of, and gives the jury sort of something else to react to other than just this crazy high number. Next slide, please. Jury instructions are another real opportunity, and I think too many trial counsel kind of tend to think of jury instructions sort of as a throwaway, but they're certainly not. You want to be looking really closely at any reptile jury instructions that the plaintiff's offering and objecting to those overtly and expressly, preserving that argument, and preferably in writing. And also looking for opportunities in the jury instructions to tether the case and the damages to the specific parties and the specific facts. Because the whole premise of the reptile theory is to kind of take the jury out of the particular case in front of them and be thinking about these sort of larger societal issues or sending messages. And so the more that you can kind of tether things back to this particular plaintiff, this particular set of supervisors and decisions, that's going to be really helpful in kind of keeping the jury grounded. And now Lynn is going to talk a little bit about, in the event of an adverse verdict, how do you kind of think about choosing a team to lead the post-trial motions and appeal? Next slide, please.
And the next one. So listen, the first thing I want to say is that following a judgment, usually you're knocked on your heels. Everybody wants to talk to you about what to do next, but time is really of the essence. And the reason time is of the essence is that as soon as you get a judgment, the clock starts ticking on important deadlines for you to overturn it, either on a motion for a new trial, a remittiture, and a judgment as a matter of law motion. Remittiture is basically the motion that says the amount of money that the jury awarded ought to be reduced for the following reasons. Or, Your Honor, you should grant a new trial for the following reasons, because the jury didn't see this important piece of evidence, or plaintiff engaged in behavior that was inappropriate and relied on passion and prejudice, and the jury was inflamed in a way that they shouldn't have been, and therefore they weren't impartial, or any number of reasons why you're entitled to judgment as a matter of law and for the judge to take away the verdict. You're also going to have appeal deadlines and notice of appeal deadlines as soon as those motions get decided. So it's a substantial undertaking to draft these motions because counsel needs to review all of the trial transcript, as well as all of the exhibits, all of the objections and rulings. And so don't wait too long to pick counsel or decide who's going to be your team to do the post-trial motions. Next slide, please. The other thing is, and this is something that sometimes is surprising to companies, it's not obvious that the trial team should handle the post-trial motions and the appeal. Sometimes the trial counsel's deep knowledge of the record is an important resource, but one, sometimes they don't have appellate experience, and two, sometimes they don't want to call attention to mistakes they made during trial, or worse yet, they don't even understand that they made mistakes during trial. They don't even understand that they should have made an objection to something, or they should not have allowed an exhibit in, or an exhibit that came in created passion and prejudice. It doesn't mean they weren't good trial lawyers, and I'm not throwing them under the bus, but appeal lawyers, appeal specialists know exactly what to look for. They know what the laws are in that jurisdiction for getting things overturned, and they're frankly more efficient because they know exactly where to look, what to look for, and they know what arguments to make that might be successful in getting your judgment overturned, getting the judge to take it away as a judgment as a matter of law, or perhaps more importantly, getting it remitted. So if trial counsel was effective at trial, they may be great trial lawyers, but not great appeal lawyers. And it's very hard for someone to look at their own trial and say, gee, I should have done that, or I should have done that, or that objection really got me into trouble. So maybe trial counsel should handle the post-trial motions, but maybe not. Maybe you should hire an appeal specialist to work with trial counsel who has knowledge of the record, but it's not necessarily obvious. So really think long and hard about that quickly. Next slide. So your ideal team for the post-trial motions will have trial experience, will have post-trial motion experience, appellate experience, subject matter expertise, and each of these things is different. I know a lot of really great trial lawyers that aren't great appellate lawyers, and I know a lot of great appellate lawyers that actually aren't great trial lawyers. They aren't particularly charismatic people, but they're brilliant when it comes to writing and filing and winning appeals. So it's just something to think about. It's not a diss on the trial lawyer or on the appellate lawyer. They're different skills. Next slide, please. Obviously, it's important to have familiarity with the particular appellate court and local rules. Consider local counsel. Many an appeal has been won and lost because you've blown a deadline or not filed the notice in a particular way. Lawyers are busy. Find somebody who can dive into the case in depth right away. Even though they may be a great lawyer, if they've got 4 other appeals going, they may not be your great lawyer at this time for this case. So really think about whether they have experience and the time to jump into the weeds in your case. One thing that Dawn alluded to, and you can go to the next slide, but I want you to know that all is not lost. There was a recent big verdict, and I won't talk about the name of the case or the defendant, in Philadelphia recently, where there was a $600,000 compensatory damage award and a $25 million punitive damage award. And the first thing I do when I look at those verdicts is I shake my head and then I smile, because I know, for example, if I were to get that appeal, one of the first arguments I would be able to make is that the punitive damages award is not at all proportionate to the compensatory damages award. And the BMW v. Gore case in the Supreme Court says that at the most, it should be a 4-to-1 ratio of punitive damages to actual damages, or punitive damages to compensatory damages. And sometimes it can be as little as a 2-to-1 ratio, and that, you need to remit that or reduce that down. And Dawn and I have experience getting awards like that other firms have tried, reduced based on BMW v. Gore, based on arguments that the jury was encouraged and moved by arguments that were inappropriate, reptilian arguments, passion and prejudice arguments. And then there are also guidelines in each circuit and in each state about how emotional distress damages ought to be determined and decided by a jury. And so you can attach the emotional distress damages or attack them as well by looking at those guidelines if the jury didn't follow them. So I just want to say that even if you get a $25,600,000 verdict in an employment case, it may and it likely won't stick if you hire the right post-trial counsel. And that's why it's so important to think about that. Think about whether and how to substitute or add counsel and how that'll appeal to the court. Some courts will local you to death. And some judges, for example, I was in court in Texas, and I walked in, thank goodness, with local counsel, because the first thing the judge said to me was some comment about carpetbagging. Aren't you from the Northeast? Aren't you a Yankee? Aren't you carpetbagging in this court? And I said, well, Your Honor, I really appreciate your having me here today. I'm here with so-and-so who practices right here in Houston, and has been here, all week with me, blah, blah, blah. Literally softened up like butter because I had my local Houston lawyer with me in Texas, and my carpet bag all of a sudden wasn't so big. But I really would advise you to consider whether it's important to have local counsel with you, what the judges are like in your jurisdiction. And you don't always have to remove trial counsel from the pleadings, even if they've lost the trial, because maybe you haven't lost confidence in trial counsel at all. Maybe you're just bringing in an expert, but think about that. Those are things to think about. So sometimes you may want to remove trial counsel because they did not do a good job, and you want to send a message to the court that you've brought in someone who's going to take a fresh look at the case. All those are things to consider. No decision is right or wrong. Next slide. I think you've made it long enough that you deserve a CLE code. You've listened to us banter on. So the CLE code is SS, as in Seyfarth Shaw, 4179. 4179. And I think we're going to pass around some documents at the end of the presentation that you fill out and send back to us in order to get your CLE information. Dawn, I'd like to pass it back to you for other considerations for post-trial motions and appeal.
Yes, thank you. Next slide, please. So in terms of the substance, if you do find yourself with a bad verdict, the very first thing that your post-trial team will need immediately is the judgment itself. All of the dates will run from the date of that judgment. You will need the verdict form as completed by the jury. You'll need the jury instructions as given, but also as proposed by each party, and any written objections to those jury instructions, any verdict form that was proposed by both of the parties, and any directed verdict motion and ruling if those are written as opposed to simply verbal on the record. That will be kind of your basic infrastructure for what you need as a post-trial team to get going with the post-trial proceedings. Next slide, please. As Lynn said, time is of the essence. This is basically an emergency practice. You want someone on the team immediately to begin compiling the record, getting the transcripts if you don't have them already. From daily transcripts, you want to order those immediately and open up a line of communication with the court reporter. Pay for expedited if your budget allows, because every day makes a big difference in this setting. And you do want to ask for that charge conference to be transcribed at trial if you are given the choice, so that you have access to that for post-trial motions and appeal. You want to make sure you have a complete set of the exhibits as they came into evidence, as well as any exhibits that were offered and marked for identification but not actually allowed, as well as motions in limine and rulings. And so as a practice point in the trial stage, you want to have as much of this on the record as possible so that you can have access to this for the post-trial team.
Can I just interrupt you, Dawn, for 1 minute? Almost every time that I've had a charge conference, the judges said, oh, let's go back to my chambers. Let's retire to chambers and chat about the charge. And that's your charge conference. And there's no court reporter there. Sometimes the judge has asked, do you want the court reporter there? Answer's always yes. And if you can respectfully ask the judge, I know we're going back to your chambers, but do you think it would be okay if we brought a court reporter with us so that we can transcribe the charge conference? You may get no, but try it. It is not always the case that you're sitting in open court doing the charge conference with a court reporter handy. And so sometimes you have to respectfully request that the court reporter come back into chambers.
Yep, absolutely. Next slide, please. And so then the team will be reviewing those pleadings for any prejudicial error. So, is the judgment consistent with the verdict, with any court rulings, with the law? Are the verdict form and instructions proper? Are they consistent? Are they internally consistent? Sometimes verdict forms are not. Did the jurors follow instructions? Did the court make an error in declining any of the language that was proposed by you? And motions in limine, were there adverse rulings that were improper? Were those issues preserved? You want to be, the post-trial team will really be looking very carefully at the record to see kind of what went wrong and what is going to be a winning argument to get the verdict remitted, which means basically a court-ordered reduction of the verdict, or to get either a new trial or a judgment as a matter of law. Next slide, please. And, read the transcripts. This is something that Lynn and I have seen again and again, where sometimes, somehow, there are post-trial teams who think, well, it's a lot of work to read all of the transcripts. We don't really have to read them all. We can kind of rely on trial counsel to point us to key moments. There is no substitute for someone who's a sophisticated trial and appellate lawyer reading the transcripts and finding where things went south. Because if you've ended up with an explosive verdict, something went wrong somewhere, and the team should be looking at the record to see what happened. So are there erroneous evidentiary rulings? Does the evidence support the verdict? Does the evidence support the damages? Was there something improper in the opening or the closing? Where, and particularly with reptile theory, where were the invitations for the jury to make a verdict based on passion and prejudice rather than on the evidence? Because it will be there in the transcript. And ideally, your trial team will have objected in real time on the record so that that was properly preserved. Was there any impropriety in the jury selection or any juror misconduct? Next slide, please. And, you know, as I said, you also are looking at whether the error was properly preserved. So at the charge conference, before the charge was actually given, was the error, any arguments about the verdict form, was that preserved adequately? Motions in limine, was that? Because you really need a combination of both an error and something that was preserved at trial in order to try to remit the verdict or get a new trial. Next slide, please. And, you know, again, it's really just checking the transcripts for whether any errors were preserved. Next slide, please. And then, you know, what we do when we are handling these is we really make an effort to organize the issues, to kind of, we sort of have a way of organizing it where we're looking at what were all the errors, where were they preserved, with citations to the record, so that we can then go about the process of kind of identifying which issues to select to focus on in the post-trial motions and appeal. Next slide, please. And, you know, it's one of the most interesting parts of doing these kinds of cases is to make these selections, because you're not necessarily going to argue every error. It's really about finding the ones that were the driving force behind the explosive verdict. And the ones that where your standard of review is most favorable and where you're most likely to actually have success in getting the number remitted. Next slide, please. And throughout this post-trial process, and consistent with how you, hopefully your trial team has called out these tactics directly during the trial, you're going to want to continue to do that during the post-trial motion. So where were there improper arguments made? Where were there invitations for the jury to react based on passion and prejudice? Where were there evidentiary rulings that allowed reptilian stuff to come into the record that shouldn't have? Next slide, please. I see we have a lot of great questions coming in, and we are also coming up on our time. But one thing we wanted to do is to ask, you know, kind of solicit input from the folks who are attending today as to whether you're interested in more content on best practices for post-trial motions and appeal, because we weren't able to, of course, in today's allotment, there's so much material here, it was hard to get through all of it. But if you indicate interest in the chat, that will help us in deciding about future programming. And Lynn, do you think we have time to take up one or two of the questions? There's so many good questions in the Q&A.
Yeah, I think one or two are easy to answer. Someone asked if Seyfarth encouraged employers to avoid doing business in some of these venues that deliver more explosive verdicts. And the answer is no. We don't tell people not to do business anywhere. And frankly, you can get an explosive verdict anywhere. And it really just depends on the case, the plaintiff, and the particular complement of jurors that you have. So no, I don't. I will say that places like California, New Jersey, in the Third Circuit, in the Ninth Circuit, do tend to produce really big verdicts that I've seen historically, but now we're seeing them in Massachusetts and places that we didn't see them historically before. So no, I don't think we would discourage any employer from doing business anywhere just because of that. Just hire good lawyers there. And then another question is, does Seyfarth Shaw encourage clients to settle as early as possible in order to avoid having a jury decide the result? The answer is absolutely not. Every case stands on its own facts, and certainly if there are cases that we think present difficult facts, we will strategize with the client and manage their expectations about the likelihood of success. But we never encourage clients to settle to avoid a jury trial, because we do that for a living. What we may do is give them a better sense of the likelihood of success and say, we think you have a, 40% chance of losing this case. And if you do lose, there's a chance that you'll get an explosive verdict because of this particular sympathetic fact and this particular plaintiff who we know employs passion and prejudice and reptilian tactics. But each case stands on its own. And we try to advise clients and manage their expectations as best we can.
What I would add to that is that I think also, and I think we alluded to this briefly, that we're seeing also explosive demands. So as the plaintiff's bar sees these verdicts come out, they're all convinced that that every trial is going to be the next $25 million trial. And so we're seeing just crazy demands in some cases. And so that can make settlement really difficult and can sometimes put the employer in the position where it's just not, it's not practical to settle it for, $15-18 million. It's worth rolling the dice. So it really does depend a lot on the case.
And one thing I will say that I've been saying to plaintiffs' lawyers when I see these demands, and the demands usually say things, you saw the blah, blah, blah case come out the other day with a $25 million verdict. You should pay us $15 million. And I say, why don't you call me back after the post-trial motions have been decided and that case is really an $800,000 case, and then maybe we can talk about mediating. Because I truly believe that many of these big verdicts, if they're handled correctly, will be remitted and reduced exponentially. I mean, from 26 million to 800,000 is not an unreasonable amount to be remitted, given the facts of the case and the kind of proportionality of the damages. So what I would say is, before you decide that your case is going to be an explosive verdict, let's see what happens to some of these verdicts after appeal. And of course, the media doesn't like to report on that quite as much as the explosive verdict. So you may have to dig a little bit more for that information or ask us.
Yeah, I think we're at time. There are a lot of other questions and I think some good ideas for us for future programming that people would like to see on some of these, including more information on discovery and settlement tactics, how to deal with mediators on reptile tactics, lots of good ideas in here. So stay tuned for more programming on explosive verdicts.